green card holders turned US citizens now face risk of losing citizenship. A 2025 investigative documentary article, The American Dream at Risk. When citizenship is no longer permanent. For decades, the promise of the American dream has drawn millions of immigrants to the United States, a dream built on opportunity, liberty, and the hope that hard work and integrity will be rewarded. Among the many paths immigrants take, the most cherished destination is US citizenship, the ultimate symbol of belonging and security. But in 2025, that promise seems to be on shakier ground for a certain group of Americans. Those who first arrived as green card holders, followed the rules, and eventually became naturalized citizens only to find themselves at risk of losing it all. In March 2025, the US Department of Justice, DOJ, quietly issued a new internal memorandum that sent ripples through the immigrant community. The memo instructed federal investigators and prosecutors to prioritize investigations and enforcement actions into cases of fraudulently obtained naturalization. In plain terms, people who lied, concealed facts, or made errors in their citizenship applications even decades ago may now face denaturalization, the legal process of being stripped of American citizenship. The integrity of the US naturalization process is vital, the DOJ memo stated. Those who obtained citizenship through fraud or material misrepresentation must be held accountable. It was not the first time this had happened in US history, but the timing, language, and scope of this new initiative raised alarms. Advocacy groups described it as a potential tool for intimidation. Immigration attorneys began fielding panicked calls from clients who had been citizens for 10, 20, or even 30 years. For those who once believed that citizenship was forever, the terrain has shifted dramatically. The road to becoming American, green card to citizenship. To understand the weight of this policy shift, one must understand the journey of millions who became US citizens after years of legal immigration. The typical path begins with a green card, officially called a permanent resident card. For many immigrants, it's the first sign that they are welcome, allowed to live and work in the United States indefinitely. After 5 years, or 3 if married to a US citizen, green card holders can apply for naturalization. But becoming a citizen is more than paperwork. It requires proof of good moral character, continuous residence and physical presence in the US, ability to read, write, and speak basic English, understanding of US history and civics, an oath of allegiance. Before naturalization is granted, applicants undergo thorough background checks. They must disclose all prior names, addresses, marriages, children, arrests, and affiliations. One mistake, accidental or deliberate, can have massive consequences later. And it is those past mistakes, even ones buried under decades of productive life, that are now being unearthed. What is denaturalization? The legal sword no one expects. Denaturalization is a legal process by which the US government revokes a person's citizenship not through deportation, but through court action proving that the citizenship was illegally obtained or granted due to fraud. Historically, denaturalization was rare and typically reserved for egregious cases. Former Nazis, war criminals, or spies who concealed their past to enter the US. But over the years, the criteria have expanded. Under US law, someone may be denaturalized if they concealed material facts during their naturalization process. They willfully misrepresented facts to immigration officers. They were affiliated with terrorist organizations before applying. They committed crimes of moral turpitude that would have disqualified them at the time. Unlike citizenship by birth, which is nearly impossible to revoke, naturalized citizenship has always carried a fine print clause that it was granted conditionally, pending truthfulness. What's changed in 2025 is not the law, but the urgency and intensity with which the government is choosing to pursue these cases. Why now? The 2025 DOJ directive. The DOJ memo released in early 2025 was not announced with fanfare. There was no press conference, no speech from the Attorney General. Instead, it quietly landed on the desks of U.S. attorneys across the country as part of a broader document outlining immigration enforcement priorities. The memo reads in part, "To protect national security and the rule of law, denaturalization efforts should be pursued where citizenship was procured through fraud, deception, or concealment of material facts. Several key points stood out. The DOJ plans to expand resources to identify cases eligible for denaturalization. It calls for a review of previously closed files where fraud may have gone undetected. It encourages coordination with DHS, FBI, and ICE to identify targets. Experts believe the push is partly political, driven by growing anti-immigration sentiment in some corners of American society, as well as broader concerns about terrorism, global migration, and border security. In an election year, immigration always becomes a high-voltage topic, but to many, this policy goes farther than border walls or visa restrictions. It challenges the very permanence of American citizenship itself. Real stories and legal precedents. In the next section, we'll explore how this issue has unfolded in real life, from elderly men stripped of citizenship for war crimes to ordinary mothers and fathers now facing deportation over decades-old application errors. We'll also look at the legal precedent that makes denaturalization possible and why critics say it's a slippery slope. Real people, real consequences, how denaturalization impacts lives. The word denaturalization sounds abstract, almost clinical, but behind each case is a person, often a family, and sometimes an entire lifetime built in the United States. As the Department of Justice sharpens its focus on denaturalization in 2025, real stories of those impacted bring the legal process down to earth, revealing just how life-shattering the consequences can be. Case 1. The grandfather accused of lying on a form 25 years later. In 2022, Mahmoud, a 63-year-old man originally from Egypt, was served with a denaturalization notice by the US government. The accusation: he failed to disclose a brief detention he experienced during political protests in Cairo in the early 1990s, a time before he even applied for a green card. When he applied for citizenship in 1998, Mahmoud left that incident off his form. He says it was because he didn't believe it was an arrest, since he had never been charged with a crime. He passed the interview, took the oath, and built a quiet life in Michigan as a small business owner. He has 3 children, all born in the US. Now, he faces losing everything, including his right to live in the country. "I didn't hide anything," Mahmoud told the Detroit Post. "I didn't think it mattered. I've paid taxes for 25 years. My kids are doctors. My wife is a nurse. Why now?" The government insists that omission of any legally significant detail, even one that would not have disqualified him at the time, is grounds for denaturalization. Case 2. A survivor turned suspect, the Bosnian War echoes in US courts. One of the most high-profile denaturalization cases involved Duško Tadić, a man who had served in the Bosnian Serb forces during the Yugoslav wars in the 1990s. He was granted U.S. citizenship in 2001 after claiming to be a civilian refugee. Years later, investigations revealed his involvement in wartime atrocities. He was not only denaturalized, but also extradited to stand trial at the International Criminal Tribunal in The Hague. While Tadić's case was extreme and tied to war crimes, it set a powerful legal precedent. If you lie or withhold information even decades ago, the government has the right to strip your citizenship. Case 3. The domestic worker deported over a name error. Fatoumata, a woman from Senegal, worked in the United States for 18 years as a nanny and home caretaker. She became a citizen in 2009. In 2023, a small discrepancy was discovered. She had used a different spelling of her last name in earlier immigration documents, not to deceive, but because of a clerical inconsistency on her original visa application in Dakar. The Department of Justice argued that the inconsistency meant her identity could not be properly verified at the time she became a citizen. "She never committed a crime," said her attorney. "She paid taxes, worked legally, raised American children, but a spelling error might cost her everything." Though she's now fighting deportation, her citizenship has been officially revoked. Denaturalization, a tool once reserved for Nazis. To fully grasp how this tool became so far-reaching, we must go back to the post-World War II era. In the 1950s and 60s, US authorities discovered that several former Nazi officers had immigrated to the country, hiding their wartime affiliations. These men had been naturalized, sometimes even working in federal agencies or as scientists. The US began pursuing denaturalization aggressively through a special branch within the DOJ, known today as the Office of Immigration Litigation, OIL, Human Rights and Special Prosecution Section. Their mission: identify and remove human rights violators who conceal their past to obtain US citizenship. By the 1980s, this approach expanded to include people affiliated with communist governments, individuals with histories of genocide or mass violence, those who had committed immigration fraud. However, by the 2000s, the list grew to include people who misrepresented their marital status, concealed prior deportations, or provided false addresses, often not with malicious intent, but due to fear, trauma, or legal confusion. The expansion under Operation Janus. In 2017, under the Trump administration, the U.S. Citizenship and Immigration Services, USCIS, launched Operation Janus, an effort to identify individuals who obtained citizenship using false identities or incomplete records. Through digitization of old fingerprints, Operation Janus uncovered over 300 cases where people may have used aliases or failed to disclose prior immigration issues. From that pool, dozens were denaturalized, some prosecuted criminally, others simply stripped of citizenship and placed in removal proceedings. Legal experts say Operation Janus laid the groundwork for today's 2025 denaturalization push, which appears broader and more sustained. What happens when you're denaturalized? Denaturalization is a civil process, not a criminal one. This means you are not immediately deported, but you lose all rights as a citizen. You may become stateless if no other country recognizes you as a citizen. Your social security, passport, voting rights, and work eligibility all end. If you were a US citizen for decades, everything resets legally speaking. You can fight the process in court, but few have the resources to sustain a long battle against the Department of Justice. For some, especially elderly immigrants, the process itself feels like punishment. Families suffer too. If your spouse or children derived immigration status from your citizenship, their future may be in jeopardy. Denaturalization by the numbers. Between 1990 and 2020, fewer than 150 people were denaturalized annually in the US. After Operation Janus, that number rose to over 20 open investigations, with hundreds resulting in action. Now, in 2025, sources suggest there may be up to 50 active investigations, though the government has not publicly released full figures. The increase reflects both more powerful data tools and a political willingness to pursue older, closed files. Who is most at risk? The gray zones of citizenship. In Part 3, we'll explore the types of people and cases being targeted most frequently, from asylum seekers to marriage-based immigrants, from former soldiers to refugees. We'll also look at how even minor application errors or confusing paperwork can trigger life-changing consequences under the 2025 DOJ policy. When most people think of losing citizenship, they imagine spies, war criminals, or terrorists, individuals whose actions clearly contradict the values of their new country. But as denaturalization efforts expand in 2025, it's becoming clear that even minor errors, misunderstandings, or events from decades ago can place ordinary people at risk. This growing gray area has raised urgent questions. Who is really being targeted? What types of naturalized citizens are most vulnerable? And how much room is there for interpretation or abuse under the law? Let's examine the most commonly affected groups. 1. Refugees and asylum seekers. Refugees and asylum seekers are often among the most grateful and loyal Americans, many having fled unimaginable violence or persecution. However, their complex and traumatic pasts can make it difficult to provide precise, consistent answers on every immigration form. For example, a Congolese refugee who witnessed war crimes may fear revealing too much detail. An Afghan interpreter for US forces may hide tribal affiliations for personal safety. A Somali applicant may not know their exact birth date due to lack of records. Any inconsistency in their applications, no matter how understandable, may now be interpreted as fraud. A 2023 case involved a Syrian man who, during his asylum interview in 2010, failed to mention a distant cousin who had briefly joined a rebel group. That omission, not related to any crime or personal involvement, became grounds for revoking his citizenship in 2024. They are weaponizing trauma, said immigration attorney Dana Abbas. These people are often scared and confused, not scheming. 2. Marriage-based immigrants. Marriage to a US citizen remains one of the most common paths to a green card, but this route is also heavily scrutinized for fraud, and even minor inconsistencies can now trigger denaturalization. Examples include not disclosing a prior divorce or traditional unregistered marriage in another country, marrying while still married abroad due to local customs, marriages that ended soon after citizenship was granted, even if they began in good faith. In one case, a Filipino woman became a US citizen in 2013 after marrying her American husband in 2009. They divorced in 2014. In 2024, an anonymous tipster claimed the marriage was fake. Though there was no direct evidence, the Department of Homeland Security reopened her file. She now faces a denaturalization case. My marriage was real, she told reporters, but now I have to prove it again 15 years later. 3. War-affected immigrants and ex-soldiers. Surprisingly, some denaturalization cases have targeted former allies of the US military. One Iraqi man, who served as a translator for US troops during the Iraq War, obtained a green card in 2009 and became a citizen in 2014. In 2023, DHS found evidence that he had once belonged to a local militia briefly before switching sides. The group had later been designated a terrorist organization. Even though he had fought with US forces and was never charged with any crime, the affiliation alone triggered a denaturalization process. This raises disturbing implications. Even those who risk their lives for America are not immune to bureaucratic, retroactive judgment. 4. Naturalized citizens with past convictions. Another growing category of denaturalization cases involves individuals who are arrested or convicted of crimes, even minor ones, before their naturalization, but failed to disclose it. Examples include a shoplifting arrest in the 1980s, a juvenile record sealed by state law, a Dewey conviction mistakenly believed to be not serious enough to mention. Under US immigration law, any crime involving moral turpitude, including fraud, theft, or violence, can disqualify a person from naturalization. If someone lied or failed to disclose such a conviction, they may now be pursued for denaturalization. Critics argue that these individuals already served their time and were granted citizenship under a flawed vetting system. Reversing it years later feels more like punishment than justice. 5. People with identity issues or documentation gaps. For immigrants from countries with weak institutions, war-torn regions, or non-standard record keeping, maintaining a consistent identity throughout the immigration process can be extremely difficult. Consider a person born in a refugee camp with no official birth certificate, someone who used a nickname or tribal name instead of a legal one, multiple people in a village sharing the same first and last name. In these cases, mismatches in names, birth dates, or locations, especially if not explained, can now be flagged as intentional deception. In 2022, a man from rural Nigeria was denaturalized after it was discovered he had used his father's name as his surname in one application and his clan name in another. He had not changed his identity, but the lack of clarity cost him his US citizenship in 2024. The legal gray area, intent versus error. One of the most dangerous elements of modern denaturalization law is the blurred line between intentional fraud and honest mistake. Historically, courts have required the government to prove 1. A false statement was made. 2. The statement was material, meaning it influenced the decision to grant citizenship. 3. It was made willfully, not accidentally. But in recent years, and especially under 2025 directives, the burden of proof is shifting. If the government claims a mistake was too significant to be accidental, it may proceed with denaturalization. This can leave naturalized citizens in a state of anxiety. As immigration attorney Luis Mendoza notes, you can't prove what someone intended in 1996, but if they can't defend it clearly today, they lose everything. Technology and data mining, a double-edged sword. Another reason denaturalization cases are increasing is the US government's expanded use of biometric databases, AI, and data mining tools. With the digitization of old fingerprints, visa records, and interviews, the government is now able to connect dots that went unnoticed years ago. Operation Janus, launched in 2017, used this technology to find thousands of mismatches in names, dates, and prior immigration attempts. In 2025, similar tools are being used to scan old applications for conflicting information across years, undisclosed aliases, past deportation orders, duplicate biometric data. What once would have required months of human labor now takes seconds, with algorithms raising the risk of false positives, automated suspicion, and innocent people being caught in the dragnet. Inside the denaturalization legal process, in Part 4, we'll step inside the courtroom and explore how denaturalization cases are handled, from investigations to trials, and from legal defenses to final judgments. We'll also look at the emotional toll the process takes on families and how hard it is to win once the government has decided to challenge your citizenship.